When you walk into a disability hearing, your first instinct might be to describe your pain as constant or say you need to rest a lot. However, in this specific legal environment, those words can be a liability. Describing your symptoms with vague adjectives often results in a claim being denied. An administrative law judge cannot make a ruling based on feelings. They are searching for quantifiable mathematical limits. If your testimony is built on unquantifiable suffering, it obscures the data the judge is legally required to evaluate. Over the next 5 minutes, we will build a testimony preparation outline designed to translate your physical and mental symptoms into those precise numbers. Grab a blank piece of paper and a pen. We are going to map out your limitations right now. Relying on vague adjectives makes it difficult for a judge to satisfy the legal requirement for objective math, which is the standard they are bound to follow. We begin by mapping the physical limits of your spine and hands. You must establish strict timeframes for exactly how long you can sit, stand, and lift. Words like sometimes or a while are banned. You must provide the judge with exact minute counts. Write down your maximum sitting limit, then define your minute 16 rule. State the exact physical consequence that occurs the moment you exceed your limit. Apply this same precision to your hand functions. Write down exactly how many continuous minutes you can type or hold a phone before your hands go numb or you drop the item. We must account for the physical cost of an activity. Don't admit to doing chores without explaining the heavy toll they take on your body. Choose a common chore, like grocery shopping. Write it down, followed by any accommodations you use, like leaning on the cart as a walker, and the recovery time required, such as 2 hours of mandatory rest immediately after. Documenting the specific cost of an activity helps demonstrate that you do not possess the stamina required for a standard workday. For mental health limits, we must address the vocational expert, or VE. This is the professional who will testify about your ability to maintain focus and pace. The VE follows a strict threshold. An employee is generally considered unemployable if they are off task for more than 10 to 15% of the workday. In practical terms, that is a window of only 6 to 9 minutes per hour. On your paper, estimate the specific number of minutes per hour you spend staring at a wall or losing track of tasks due to anxiety or depression. Next, write down your days missed per month. These are days when your symptoms are so severe it is impossible for you to leave the house. Missing more than 1 day of work per month is typically viewed by a VE as a threshold that precludes standard employment. Translating your mental health struggles into minutes off task gives your attorney the specific metrics needed to address the VE's testimony. We must also document the frequency of your restroom use and any disruptive side effects from your medication. Most employers follow a rigid schedule: a 15-minute morning break, a 30-minute lunch, and a 15-minute afternoon break. Calculate the frequency and duration of the breaks you require due to medical urgency or medication-induced fog. Note how these compare to the standard blocks. Next, evaluate the urgency factor. Determine if you have control over when you take these breaks, or if your needs are immediate. If you have no control, write this statement on your paper: I cannot wait for a scheduled break. I must go immediately to avoid an accident. Proving that your medical needs exceed standard workplace allowances makes it difficult for a VE to suggest you can maintain a regular job. Review your paper. You have now established the specific mathematical parameters needed for your testimony. This data is your defense against the vocational expert suggesting ghost jobs, outdated roles like an office helper or a dresser. Your attorney can use your off-task math to argue against these suggestions by citing the Modern Occupational Requirement Survey, which shows that these jobs require higher cognitive focus than the 1970s descriptions suggest. These numbers provide the evidence-based foundation required to exclude vocational suggestions that do not account for your actual limitations. Entering your hearing with this mathematical breakdown aligns your testimony with the objective standards the judge uses to decide your case.